Hey everybody, welcome, welcome to Hidden Horror. Thank you for spending this time with me. I appreciate that. Let's get started. Hey everybody, welcome to Hidden Horror. How are you guys doing today? How are you feeling? How's everything going? How's your weekend going? I hope all is well with you. So today I'm here. I wasn't going to bring this. I had been working on the IGG and I'm still having a very hard time finding the courtroom testimony regarding the IGG, but I have the motion, I have the court's order ready, but I don't have the video with the testimony. So I'm trying to still find that. But instead, I'm here to bring you an update on what's going on in the Bryan Kohberger case. Now, we know Bryan Kohberger, he had his huge hearing. So much happened in the April 9th hearing. All of the motion and limines were discussed, and I was thinking about doing a very short video to kind of go over all of the motion of limines. I do have something that the court prepared with all of the motion and limines and the judge's order, so he made it very easy to follow. So I might do that video. But the video I'm more concerned about, again, I'm bothered with the IGG, but I'm still trying to find the actual courtroom testimony, which I believe happened in 2024, but it's very hard to come across. So I'm working on that. But in between time, we have, of course, the pretrial hearing that happened. And all in all, we get this bomb dropped on us, the huge leak. I didn't watch it. I'm not going to say I'm not going to watch it. I'm probably not going to watch it. I don't want to watch it. I don't want to have my thoughts tainted. And there's so much going on, so much still that I need to cover, to go over. But I had to set that to the side a little bit because there was a motion to continue that was filed on May 20th by Bryan Kohberger because of the huge leak. So the judge at the pretrial hearing, he kind of talked about a little bit. He basically ordered both the prosecution and defense to turn over a list of all of the people involved in the case that had the knowledge, the access to the evidence that was leaked in that special, right? So he wants a motion to have a special prosecutor appointed to investigate the leak and to determine who or how many people were leaked information, evidence. This evidence was not publicly known, and that's where the issue is. And there's been leaks all along. I've said it in my videos. I've put out advisements like, hey, don't do this. This is starting to rise to the level, where you're affecting the case. It creates the issue where Bryan Kohberger rights are violated. He will not be able to get an impartial jury, and that's his right. He has a right to a fair trial and an impartial jury, and the leaks affect that. So with all of that we talked about, now the defense has come in and has hit hard. I can't even share. It's a 40-page document in the motion to continue. It's just too large. So I'm going to tell you how to get it. I'm going to read an article, and within the article, the link to the document is in the article. And I would just advise you to please use the link. I don't want to post 40 pages on my page. It's just too large of a document. I'm going to pull it up. We are going to go through it today. Excuse me, not every page because I am still sick, but I'm going to highlight maybe about half of it Some of it is references to case law. We're not going to go over any case law. We're just going to go over some of the written parts in the motion to continue. But I'm going to summarize it now. If you cannot stay for maybe this hour video, I'm going to tell you what's in there, okay? So you don't have to stay if you're not able to stay, or you don't care, you don't want to read through the documents. I understand everybody is different, and it's all good. There's a couple of moving parts, but Bryan Kohberger, he has a right to counsel. He has a right to effective counsel. They have responsibilities, and it's a death penalty case. So there's even more work to be done. So evidence has to be challenged. They have a right. He has a right to confront his accusers. He has a right to see the evidence that's against him. Okay. And in order to have an effective counsel, they have to challenge that evidence. They have to do work to learn about Bryan Kohberger's background as the defense so they know how to proceed. They know what they need to do in his case. And they have to review all of the discovery, all of the evidence, the documents, the video, the audio. That makes them be aware of what evidence could possibly be against him. And the defense has said in several hearings they need more time. They're saying that the evidence is voluminous, it's a lot. They're just not able to go through all of the evidence. And they've been getting evidence sent to them, like trickle down over time. They're still receiving evidence, and that's hard to go through. Excuse me, they don't have a huge staff doing this work. So it's problematic. And now, again, I have said to you in a past video, we're just weeks away from the start of the trial, the start of jury selection, about 2 months away, the start of the trial, about 10 weeks away. And they're not ready. They've said it in open court. They've been saying it probably for over a year in these hearings. And Judge Hippler simply said, well, just hire some more paralegals and allow the paralegals to do the work. But I believe that the defense team, the attorneys are concerned that something could be overlooked, something very important. And they want to be prepared for trial, and they want to know the evidence that the prosecution has and is going to bring forth. Okay. So let's go over the article first, and then I can show you where the link is in the article, and then we'll have a short video. We're going to go over, we'll do the video at the end to wrap it all up for us, but I want to show you the article. So let me share my screen. I have it prepared. So it's from the Idaho Statesman. Okay, and let me see if I can pull the date. It's by Kevin Fixler, and it's dated May 21st, 2025. Now, the odd thing is, I found it difficult to find in the document. I couldn't find it. The docket that I see that I'm able to view and obtain documents is very hard to find certain things. I couldn't find it, so I had to go online to get it, retrieve it. Excuse me. But in the article, and I'll just scroll down. Okay. If you want, this is something that we talked about with Judge Hippler and him wanting to order the special prosecutor and have all of the people that are actively involved, even in the past, that worked on a case, to retain their records. Do not delete any documents, any video, any audio, any messages, any records. Retain them, because this special prosecutor is going to do a criminal investigation to try to figure out who had the access to those records and who leaked those records to the public, okay? And the public being the company that did the special recently on May 9th, okay? So I don't think we need to go over that again. If you want to hear that, you can check out that video on the Hidden Horror Facebook page, or the Hidden Horror X page, or the Hidden Horror YouTube page. There's a collection, there's a playlist that's really nice on YouTube. You can just go and listen to whichever video you want information on, okay? So within the article, the link is there. It's a 40-page document. We're not going to go through everything, but we are going to go through, I would say, about half of it, okay? So let's get started with the article. It reads as follows. Excuse me. Attorneys for Bryan Kohberger, the man charged with killing 4 University of Idaho students, asked the presiding judge to postpone the long awaited murder trial this summer in Boise, citing disclosure of previously unreleased case details that may have violated the court's gag order earlier this month in an episode of NBC's Dateline. Now, I was not going to say the episode in NBC Dateline. I don't want any problems, but clearly the special was on NBC Dateline, okay? I think everyone knows that. Let's continue. Led by attorney Ann Taylor, Kohberger's public defense team filed Tuesday for the delay just 2 months before the scheduled start of jury selection in late July. Her client's capital murder trial is slated to begin August 11th. So the jury selection was supposed to start at the end of July, and then giving about a week or so for that, then the trial was set to begin August the 11th. Okay. The defense requests in a 40-page brief. So if you clicked right here, click that and it will open up the document. I'm not going to post the 40 pages. It's just too much. It's too long, and it's not all I'm not going to read it all either, okay? But you can click right there and it will take you to it if you want to review that document yourself, okay? And my apologies, okay? I'm not going to post it. It's just too long. It would be a huge document on my Facebook page, and I'm just not going to do it. I'm sorry. I apologize. Okay, so in a 40-page brief that posted to a state court's website Wednesday afternoon, came less than a week after 4th District Judge Stephen Hippler invited a formal request to consider appointing a special prosecutor to investigate the source of the Dateline information. The legal filing signed by Taylor referenced the need to protect Kohberger's constitutional rights to a fair trial, including to provide enough time for the defense to review all outstanding investigation materials to prepare to defend their client effectively. So that goes to effective counsel. He has a right not to just have any counsel, but an effective counsel, a counsel that's going to file motions, to make objections, to write responses, to review any evidence, any discovery, any documents. That's an effective counsel, okay? While prompt administration of justice is important to both the state and Mr. Kohberger, the constitutional guarantee of a fair trial outweighs modest delay, Taylor wrote. And because the majority of cases ending in the death penalty are later overturned for error, the public interest lies in ensuring a fair trial in the first instance. And she talks about a lot of, factual information, like the idea that they will be convicted at trial and then that conviction will later be overturned in these death penalty cases. I understand why she's citing that, but I'm not going to talk about that, case by case. That's just something that is known, that a lot of cases that have the death penalty involved, they're going to have more scrutiny and they are likely to get overturned more due to errors in that initial trial. But I'm not going to talk about that. I'm just going to focus on the main idea, which I believe is the right to effective counsel, the need for them to be granted this delay so that they can have more time to review all of the discovery, evidence, information prior to the trial. I believe those are the key things, but I understand why she's bringing up the death penalty again, okay? Excuse me. Let's continue. The defense has yet to file any request for the appointment of a special prosecutor to suss out potential sources of the leaks to Dateline. Hippler last week, excuse me, ordered the prosecution as well as the defense to preserve all documents and communication and submit to him a list of anyone who has been involved in the case. And I don't think it's really just being involved in the case. I think you want to zone in, focus in, narrowly focus in on who had access, knowledge to those records. Who would have access to Bryan Kohberger's cell phone data, photos, pictures, history? Everybody doesn't have access, right? So that is most interesting to me. Um, yeah, that is very interesting to me. Let's continue. Kohberger, 30, is suspected of fatally stabbing four U of I students in November of 2022 at an off-campus home in Moscow. At the time, he was a PhD student in the criminal justice and criminology department at Washington State University in nearby Pullman. Kohberger was arrested in late December of 2022 after a nearly 7-week homicide investigation. The victims were Madison Mogan, 21, of Coeur d'Alene, Kayleen Gottclaves, 21, of Rafton, Zana Canolo, 20, of Post Falls, and Ethan Chapin, 20, of Mount Vernon, Washington. Excuse me. The three women lived in the home on King Road in Moscow with two female roommates who went physically unharmed. And they're talking about during the attack, the murders on November 13th, 2022. Chapin was Cornado's boyfriend and stayed over for the night. Kohberger, who is originally from Eastern Pennsylvania, faces 4 counts of first-degree murder and 1 count of felony burglary. A judge entered not guilty pleas to all charges on his behalf, and his defense has maintained his innocence for more than 2 years, leading up to his high-profile trial, which was moved from Moscow to Boise late last year. Idaho is one of 27 U.S. states with capital punishment. If a jury finds Kohberger guilty, prosecutors intend to seek the death penalty. Kohberger's attorney took particular aim at the Dateline episode in Tuesday's filing and pointed to a current or former member of law enforcement or the prosecution team as the likely source of the information. The episode cited unnamed sources close to the investigation and included unreleased surveillance camera footage from a neighboring home, as well as a variety of data purported to be directly from Kohberger's cell phone, such as Google searches, photos, and call logs. Excuse me. The court's non-dissemination order, colloquially known as a gag order, prevents the defense and prosecution from speaking about the case publicly outside of court. Law enforcement is included under the restriction as agents of the prosecution. The leaked materials appear carefully curated to promote a narrative of guilt, Taylor wrote. It raises urgent and serious questions about the objectivity, judgment, and credibility of the individuals tasked with investigating and presenting the state's evidence, particularly those who may be called as witnesses. The identity of those involved Their motives and any efforts to conceal their conduct go directly to the heart of witness credibility and the integrity of the state's case. They also noted that a new book about the closely watched case, the third from a major publisher before trial begins, is scheduled for release in mid July, timed to the current start time of the trial. Hitler offered skepticism in response to Taylor's position at a hearing last month that her team remained overwhelmed by the amount of information turned over by the prosecution in discovery and therefore might not be ready for trial. He suggested the defense bring on additional paralegals to help sift through any potential evidence Taylor and her team had yet to review. It sounds like you would never know what you don't know, Hitler told her. Given what you've told me, it's going to take 18 billion years to get through. Well, I don't think it'll take 18 billion years, Your Honor, Taylor responded. But the alleged information leaked to Dateline created a new avenue for the defense to bolster its pursuit of a postponement. The details released in that 2 hour special were a massive breach in the short window ahead of the scheduled trial, said Boise based criminal defense attorney Edwina Elcox. It's incredibly problematic that this happened, and it's not a neutral perspective. It's that Kohberger did it, she said in a phone interview with the Statesman. I think if there's any reason Judge Hitler grants a continuance, it's this one. They have to get to the bottom of this. Excuse me. Also, Wednesday, attorneys met with Hitler for a closed door hearing. Little is known about the remote only hearing that restricted public access other than its title, Discussion Regarding the Role of Victims. Besides the prosecution and defense teams, Shannon Gray, attorney for the family of victim Kaylee Goncalves, was listed on a court record as among those invited to attend. Goncalves' parents, Steve and Christy, have voiced their frustrations about the length of time before the trial of their daughter's accused killer begins. One step forward, two steps back. Are we ever going to get there? The Goncalves posted to a family Facebook page the day after a public court hearing last week at which Hitler scheduled another pretrial hearing for next month. Gray did not respond Wednesday to a request from the statesman for comment from his clients. At last week's hearing, Hitler said he considered the two surviving roommates technically victims of the burglary. As such, he will reserve 2 seats in the courtroom for them each day of the trial, should they choose to attend, and also said he would broadcast only the audio of their expected testimony on the court's live stream of the trial. Excuse me. I don't know whether they would have any desire to pee here, Hitler said. I suspect not, given the way they've been treated in the media, but if they do, they have seats available. Unless Hitler decides otherwise, Kohberger's trial remains on the docket for this summer at the Ada County Courthouse in Boise. He planned for it to last until November, including possible sentencing with a conviction. A continuance will ensure that Mr. Kohberger's fundamental constitutional rights are honored and that any verdict rendered rests on a fair and complete presentation of the facts, not on forced haste, Taylor wrote in the motion to postpone the trial start. Kohberger's next scheduled court appearance is Wednesday, June 18th. Okay, so I will stop sharing. Okay, so that was the article. In the Statesman article, the link is there. So now, excuse me, I think it might be good to play the video now so you can have it in video form and then we can go over the article. I was going to play it at the end, but it's probably better to just go ahead and play it. It's pretty short. You guys know I do not like long videos. So this video is provided by Cram 2 News. It's titled Bryan Kohberger's Team Argues Dateline Episode Jeopardizes Fair Trial Request Delay. It's less than 2 minutes. So let's check it out.
We are tracking some breaking news just into the newsroom. The defense team for Bryan Kohberger, the man accused of killing 4 University of Idaho students, just filed a motion to delay the trial. Thank you for joining us for Cram 2 News First at 4. I'm Mark Hanrahan. Cram 2's chief journalist Amanda Rowley read through the 40-page motion today. She is joining us live in the newsroom tonight. So Amanda, why is the defense making this request?
Well, Mark, Bryan Kohberger's attorneys explicitly cite the Dateline NBC special as a reason for pushing back the trial start date. That special, according to court records, included leaked information on the case that wasn't publicly available. Now, the motion filed today calls the special, along with an upcoming book release, highly flammable, prejudicial publicity. Kohberger's attorneys believe this publicity, just weeks before the trial, impacts the case and potential jurors. They say sticking to the August trial date would violate his right to a fair trial. The motion also suggests there's a likelihood a death sentence could be reversed if the trial isn't pushed back. It argues many death sentence cases have been reversed, mostly because the defense attorneys didn't have enough time or fully investigate key elements in the case. Kohberger's attorneys want more time to investigate the information leaks and mitigate the effects of the pretrial publicity. They say granting a continuance is a necessary step to meet the unique demands of a capital punishment case like this one. Now, the next hearing scheduled for this case is June 18th. That's when Kohberger's defense attorneys will present evidence supporting their theory of an alternate suspect. Amanda Rowley, Cram 2 News.
They don't.
Okay, so they go back to court on June 18th. They're going to talk about the alternate suspects. I'm sure they're going to talk about a lot of other stuff. This will probably be a closed hearing because, of course, unless they're vague, they do not want to reveal those alternate suspects' names at this time. I know I saw on the docket it was a lot of sealed information, so I'm not surprised about that. Excuse me. So I have to open it again. My apologies. It has been a long time that I've waited, so I have to open the document again. So I want to go over the motion to continue. I want to pull it up. I'm trying to see. Let's see. I can at least pull it up so you can see it. Okay. 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 I'm going to share my screen so I can at least have it visible for you to see. It's a really large document, but again, I'm not going to go over every piece. Okay. So it was filed on May 20th by the defense. And again, it really covers a lot of information. We're not going to talk about the death penalty stuff, but we'll read it. In fact, I may just go off of the screen. That way we can do it together. So Comes now Bryan C. Kohberger by and through his attorney of record and hereby respectfully submits the following motion to continue due to the substantial amount of trial investigation and preparation still outstanding, as well as recent and forthcoming publicity that is highly prejudicial to the defense. So again, she's coming right out and dealing with the main two issues, right? That there is substantial work to be done, preparation, investigation, all of the discovery, information, records, evidence, documents, etc. In addition to that, now we're getting hit with this public Dateline special that was a leak that released a lot of information that was not out in the public. Someone had to leak it, and now it's all prejudicial to the defendant, Bryan Kohberger. Pretty simple, pretty straightforward. Those two sentences is basically going to lay out the next foundation of the 40 pages or 39 pages, okay, in addition to the page 1, okay? So let's continue. Any conviction and sentence resulting from a capital trial beginning in August of 2025 will be unconstitutionally imposed and therefore vulnerable to reversal on direct or collateral review. So she's kind of telling this to the judge to say, listen, all of this work, all of this money, all of this efforts could be in vain because if we move forward in this trial to start in August, the defense is not prepared, and now we have the possibility of an impartial jury, which would violate Bryan Kohberger's constitutional rights. He has a right to a fair trial. He has a right to an impartial jury, among a lot of other rights, okay, that we've discussed a little bit today and then, of course, in the past. So let's continue. In making this motion, Mr. Kohberger relies on his right to be free from cruel and unusual punishment. That's the 8th Amendment. He has a right to due process, his right to a fair trial, his right to counsel, an effective counsel, right? His right to present a defense, his right to confront his witnesses. So that means that he has a right to cross-examine them, to confront them, to ask them questions, okay? He has a right to a fair trial, so it can't be the deck stacked against him. All of this evidence released early, all of this information, records, and tainting of the jury, that's not fair. That's not a fair trial, okay? He has a right to reliable sentencing determination and other rights safeguarded by the 5th Amendment, 6th Amendment, 8th Amendment, and 14th Amendment of the United States Constitution, Article 1, Section 6 through 8, and 13 of the Idaho State Constitution, okay? So because this document is so large, she gives this huge table of contents. We're just going to skip down and get right to it, okay? So one of the main arguments is argument 1. This court has an obligation to uphold Mr. Kohberger's constitutional rights by vacating the trial date, meaning either canceling it, pushing it back further, rescheduling it, getting rid of it at this time, okay? Because defense counsel, we need additional time to review discovery, okay, and to prepare for the complex merits and sentencing phases unique to death penalty cases. So I'm not going to read all of this, okay? We're just going to pick out some things. But the court has an obligation to enforce the constitutional rights of all persons, including prisoners, okay? She's going to start talking more, but she says, as detailed in this motion, moving forward with the capital trial in August will infringe upon Mr. Kohberger's constitutional rights as counsel requires more time to review discovery, complete investigations, and prepare for a trial. When considering this request for a continuance, the court must weigh the issues against the heightened need for reliability in death penalty cases. So we're not going to look at case law. We're just going to move forward. Okay. And I'm going to move forward. We're going to jump all the way down to page 5. Okay. The 6th Amendment entitles Mr. Kohberger to the effective assistance of counsel at both the merits and penalty phases of this capital case. So we're going to jump down. We're not going to talk about any case law. Okay. In capital case, counsel must meet specific professional obligations to be constitutionally effective. Excuse me. So for her to even be, and when I say her, I mean Attorney Ann Taylor, to be assigned to the case, she has to have meet specific professional obligations, okay? So we'll go into that a little bit. The ABA guidelines outline the professional expectations and obligations for counsel in death penalty cases. So she has to be, if you want to say death penalty certified or qualified, and she is. She's probably one of few to be able to handle this case. These guidelines are not merely aspirational, they represent the current consensus on what is necessary for effective representation in capital cases. The Supreme Court has consistently referred to the ABA guidelines to determine the prevailing professional norms for counsel's performance. So then she goes into examples and all of that. So we're just going to, skip down. We are going to continue, and let's see where we're going to now. So in addition to the effective assistance of counsel, Mr. Kohberger has the right to a meaningful opportunity to present a complete defense, okay? And that's due to the due process clause. This right takes on special significance in capital cases. The right to present a meaningful defense must take precedent over any countervailing state evidentiary rules or other procedures that might be acceptable in the context of non-capital criminal cases. So she's citing a lot of case law. Okay, so we're jumping down now. Mr. Kohberger is also entitled to an individualized sentencing determination, a constitutional right that is uniquely reserved for defendants facing the death penalty. So we're not going to talk about the death penalty so much. He may not even be convicted. So we're just going to move on from this. We have a little bit more. We'll read this. The U.S. Supreme Court has repeatedly emphasized that in a capital case, a jury must be given the opportunity to consider all evidence that may weigh against a death sentence for any particular offender. Okay, this evidence includes anything at all from the defendant's life history and cannot be limited. So this is another big part of this document, and it's knowing the history of the defendant. Okay. And that goes to, if there is a conviction, are there any mitigating circumstances that the jury should consider? But I don't want to go through and read all of that, so we're going to move on. We're going to go to the next one. The right to qualified expert assistance as part of the guarantees to effective assistance of counsel in an individualized sentencing proceeding. We're not going to go over this so much. I think I'm jumping down to page 11. Yeah. Okay, so we'll read a little bit of this. With respect to the minimum requirements counsel must meet in investigating for the merits phase of a capital case, With respect to investigation for the merits phase, the ABA guidelines are clear that counsel must thoroughly investigate and challenge every minute piece of the evidence the state purports to have. To assume the accuracy of whatever information the client may initially offer or the prosecutor may choose or be compelled to disclose is to render ineffective assistance of counsel. The defense lawyer's obligation, including not only finding, interviewing, and scrutinizing the backgrounds of potential prosecution witnesses, but also searching for any other potential witness who might challenge the prosecutor's version of events and subjecting all forensic evidence to rigorous, independent scrutiny. So she's saying, I'm doing my job. Ann Taylor is saying, I am interviewing, I'm scrutinizing the backgrounds, I'm looking into these witnesses, and I'm also searching for other witnesses who can challenge the prosecutor version of events. And all of this can be done under scrutiny, rigorous, independent scrutiny, okay? In addition to a complete investigation of every piece of the state's case, counsel is then responsible for identifying and considering all legal claims potentially available, even if those claims have consistently lost in that jurisdiction. So it doesn't matter if people aren't successful. For example, presenting the information about Bryan Kohberger's autism spectrum disorder, the ASD. Yeah, it might not be successful, but she still has to bring it forth. She has to challenge it. It's her responsibility, even if people haven't been successful and they've lost in the jurisdiction, to bring that forth. And she's right, okay? So the obligation places a significant high burden on defense counsel than in a normal capital case. Okay, her burden is even higher. It's harder for her. Okay, she has to do more work. Okay. Now, yeah, we still continue on. Counsel must conduct an exhaustive, unparalleled life history investigation, analyze hundreds of documents and interviews, and compile all of this information into a cohesive narrative for the sentencing phase. Okay, so she has to know all these aspects of Bryan Kohberger's entire life, his family life, his history, okay, his past, all of that is central to the case. Okay, facts. So let me read this. The defense must conduct an ongoing, exhaustive, and independent investigation of every aspect of the client's character, history, record, and any circumstances of the offense or other factors which may provide a basis for a sentence less than death in order to meet their constitutional obligations. Okay. So I do want to go through this. I think it's important. So compiling a comprehensive life history for a capital sentencing phase requires two primary responsibilities, which are dependent upon each other, as further explained below. These responsibilities are first, collecting and analyzing records from the client and the client's family life history, and two, interviewing individuals who have touched the client's life or who may be able to shed light on circumstances shaping the client's life. It is well established that life history records that must be collected include, but are not limited to, all records that may be in existence and which bear on any of the following subjects. Okay, medical history, complete prenatal, pediatric, and adult health information, exposure to harmful substances in utero and in the environment, substance abuse history, mental health history, history of maltreatment and neglect, trauma history, educational history, employment and training history, military experience, multi-generational family history, genetic disorders and vulnerabilities, as well as multi-generational patterns of behavior, prior adult and juvenile correctional experience, religious, gender, sexual orientation, ethnic, racial, cultural, and community influences, socioeconomic, historical, and political factors. They have to look at all of these things that make up a person and their family, okay? It says contemporaneous records are intrinsically credible and may document events which the client and other family members were too young to remember. What if they were a small child? They may not remember. Too impaired to understand and record in memory, too traumatized, ashamed, or biased to articulate, or events which the client knows nothing about, but which may document significant events or conditions in the client's life. Okay? In addition to collecting and analyzing those life history records, the defense team must identify, locate, and interview life history witnesses in a culturally competent manner in order to produce confidential, relevant, and reliable information. Lay witnesses that must be interviewed include people such as the client's family, extending 3 generations back, and those familiar with the client's friends, teachers, classmates, co-workers, employers, and those who served in the military with the client. It goes on and on. Social service, witnesses familiar with the client, former and current neighbors. This is a tremendous background search, right? Witnesses that can testify to the client, how they were, did they have any adverse impact, et cetera, et cetera, et cetera. Okay. Excuse me. So we're gonna go on down. I think we got a big skip here. Excuse me. We're gonna do a big jump here because they go on and on with it. We're gonna go down to page 28 because it goes on for quite some time. So we're gonna skip down to page 28. We're gonna get to more of the meat and potatoes of it. And I apologize, my eyes are getting kind of tired. Okay, so let's continue. Therefore, the investigation into the individual's life history must be completed before counsel can know the full spectrum of necessary experts for the penalty phase. This is essential because the accuracy of the evaluation relies on precise background information, and counsel must identify the appropriate type of expert to engage. Let's continue. Let me get down to it. So we're on page 28. Okay. Counsel requires additional time to fulfill the minimum requirements described above. So in the 27 pages above, we need more time. Okay. Counsel cannot review all of the relevant discovery and complete the necessary investigations prior to trial. So this is at the heart of it. We have all of the other stuff. We have the dateline issue. We have the issue learning and finding Bryan Kohberger's background, right? And then we have the issue now with all of the records, all of the discovery. We don't have enough time to be prepared for the trial date of August 11th. That's just what it's really coming down to, everybody. To me. But let's read. As counsel explained in recent filings and an oral argument, which are hereby incorporated in full for brevity's sake, it is impossible for the defense team to review the necessary and relevant discovery in a manner that allows the evidence to be integrated into the comprehensive defense case, to pursue all necessary investigations arising from review of the discovery, including into alternative perpetrators, and to address the myriad issues that continue to arise, from the state's failure to fully abide by this court's discovery and expert disclosure deadlines. So in the past, the defense counsel Ann Taylor said, I could probably be prepared for this case if I was getting the disclosures, the documents, everything timely, the discovery, but I'm not. So I'm not going to be prepared. She said it in open court several times, okay, to Judge, and also to Judge Hippler. So this is not a surprise to me. I think it's a little late bringing it up, but I guess when the Dateline special happened, it gave her another opportunity to state this again and use this as an avenue to ask to have this trial pushed back. Okay, but let's continue. Counsel requested that this court alleviate these problems by precluding the death penalty as a possibility, freeing up counsel's time to focus only on the merits phase preparation and removing the heightened standard of reliability that governs death penalty proceedings. So she's saying because the death penalty is on the table, remember the burden is higher for her, much higher, much harder. She hasn't had time to focus on other things because she's had to also deal with that. So she's saying if that was removed, then she could focus more on these other merits. But she hasn't been able to, okay? Because the court denied that motion, counsel is obligated to seek a continuance to continue reviewing discovery, complete investigations relating to the merits phase, including into alternative perpetrators, and complete investigations into red flags that have arisen in the life history investigation. Excuse me. I think I think they're allowed 2 60-day continuances, and they may have to use it. I would prefer that both the prosecution and defense be prepared and have completed their review of the discovery prior to trial. Because if something comes up, it will have to be dealt with. And she has been stating, Ann Taylor has been stating that if something comes up, she's going to address it with the court. So I would say use one of the 2 60-day continuances. But let's continue. Um, let's skip down to page 32. So I'm going to skip a little bit of this. A continuance is also necessary to investigate and remedy the prejudice of highly inflammatory publicity released just weeks before the current trial date, including the recent Dateline NBC special and a forthcoming book. So we know about the Dateline special, but there have been other specials on the Bryan Kohberger case involving the Idaho 4. Now, potentially, there could be a book. This is damning, right? This is a lot. So she's using this opportunity. Okay, let's continue. This case has garnered substantial public interest, and the court previously issued a non-dissemination order restricting the release of certain information to the public in order to preserve the integrity of the proceedings and safeguard Mr. Kohberger's right to a fair trial. On May 9, 2025, just weeks before this capital trial is set to begin, Dateline NBC aired a 2-hour episode about this case titled The Terrible Night on King Road. The program includes details and materials, including video footage, cell phone records, and photographs of documents that are not publicly available through official channels. The show repeatedly emphasizes the non-public nature of this information, stating it was obtained from unknown sources who are close to the investigation and that the materials were obtained exclusively by Dateline. Much of the investigative material presented by Dateline was taken out of context and will not be admissible at trial because it lacks reliability. So she's saying this evidence, this information, allegedly evidence, it won't even be at trial. Let's continue, The leaked materials appear carefully curated to promote a narrative of guilt. As this court acknowledged in its May 15, 2025 document and records holdover, the source of the leak is most likely someone currently or formerly associated with the law enforcement or the prosecution team. If that is the case, it raises urgent and serious questions about the objectivity, judgment, and credibility of the individuals tasked with investigating and presenting the state's evidence, particularly those who may be called as witnesses. The identity of those involved, their motives, and any efforts to conceal their conduct go directly to the heart of witness credibility and the integrity of the state's case. Oh, it's bad. The apparent leak is not only an egregious violation of the court's non-dissemination order, it enabled Dateline to gild rampant speculation with a veneer of credibility when purportedly exclusive information surfaces through a media broadcast shortly before trial, particularly information attributed to unnamed sources with access to the investigation. It carries a heightened aura of credibility and secrecy that can deeply influence public perception. Unlike official disclosures, which are typically accompanied by context and procedural safeguards, excuse me, leaks framed as exclusives are perceived as uncensored truths that the public was not meant to see. This insider framing enhances the material's persuasive power, suggesting it is both authentic and revealing of the case's hidden realities. The episode includes things such as repeated speculative assertions regarding the assailant's motives, including unfounded allegations of sexual motivation, dramatic reenactments and animations depicting the alleged crime created by the show's producers without basis in the evidentiary record, emotional interviews with individuals connected to the alleged victims, accompanied by evocative music, photos, and videos designed to elicit strong emotional responses. The broadcast repeatedly bolstered its speculative claims through the use of so called expert commentary, including individuals identified as law enforcement professionals and academics. These commentators were permitted to make sweeping assertions about the defendant's alleged motives, psychological state, and personal history, none of which are grounded in evidence before the court, while the program repeatedly emphasized their training, research, and years of experience to lend undue credibility to their conjecture. Excuse me. This type of testimonial mimicry improperly mirrors expert witness testimony in a trial setting without the safeguard of cross examination or evidentiary standards, effectively presenting the public with a one sided, unvetted narrative that shapes juror perception before any admissible evidence has been presented. While the program occasionally inserts disclaimers such as, "We don't know what happened," these brief caveats do little to mitigate the cumulative impact of an extended narrative constructed through selective imagery, emotionally charged reenactments, and detailed speculative descriptions of the crime. When viewers are presented with a cohesive, visually reinforced sequence of events, especially when paired with commentary from individuals styled as experts, the overall presentation fosters a sense of authenticity and truthfulness that is difficult for viewers to disregard. An occasional passing verbal disclaimer functions more as a legal formality than a meaningful check on prejudicial perception, and most viewers will leave with the impression that they have seen a reliable reconstruction of events. The Dateline special, which aired just weeks before the trial date, will not even be the last pretrial media bombshell. Best-selling crime author James Patterson has written a book about the murders titled The Idaho Four, an American Tragedy, scheduled for release on July 14th, 2025, just 16 days before jury selection is slated to begin. Amazon, I guess they're putting in the link. The blurb for the book describes Mr. Kohberger as a brilliant grad student. I'm not going to even read that. Let's continue. The 6th and 14th Amendment guarantees the right to a fair trial by an impartial jury. A continuance is necessary to fully investigate the leaks and to mitigate the prejudicial effects of such inflammatory pretrial publicity occurring so close to the current trial date. Excuse me. Let's see. I am going to go down to page 39. I'm going to jump down to page 39. A continuance is reasonable and necessary under the circumstances. While there is no mechanical test for determining whether a continuance should be granted, a trial court cannot deny a continuance based on a myopic insistence upon expeditiousness in the face of a justifiable request for delay. In determining whether denial of a continuance request resulted in a violation of due process, the reviewing court looks to the circumstances of the case, particularly the reasons presented to the trial judge at the time the request was denied. This request is not made lightly. Defense counsel has worked around the clock, actively preparing for trial since appointment to this case, filed all motions in a timely manner, complied with expert disclosure deadlines, and had expected to proceed on schedule. However, it has become clear that without additional time, the defense cannot complete review of the necessary discovery, meaningfully respond to all of the state's amended expert disclosures, and incorporate the information into an effective defense and finish critical sentencing phase investigations. While prompt administration of justice is important to both the state and Mr. Kohberger, the constitutional guarantee of a fair trial outweighs modest delay. And because the majority of cases ending in the death penalty are later overturned for error, the public interest lies in ensuring a fair trial in the first instance. A continuance will ensure, excuse me, that Mr. Kohberger's fundamental constitutional rights are honored and that any verdict rendered rests on a fair and complete presentation of the facts, not on forced haste. So that was a long one. But overall, they want this case to not proceed with a trial date of August the 11th. Partially, they're using the Dateline special as the reason that there will be a special prosecutor investigating, trying to uncover who the leak is, and then how do you deal with the leak after that once you find it. That could be potentially someone from law enforcement or possibly even the prosecution. And then you have this idea that if you rush without preparation and there's a conviction, this could go up and later be reversed. We might as well take the time that we need. But more importantly, the defense needs more time in their investigation, in their review of the discovery, the evidence, the documentation, and also looking into the idea of the alternate perpetrators or perpetrator, right? And they need more time. They need more time to do their investigation, to review the documents, evidence, and all of that from discovery. Now, I will give you my short opinion. I think this is smart of the defense to come before the court again and not just stating it at the hearings, but also now put in a formal motion for continuance. Excuse me. Again, they are granted 2 continuances. They're 60 days. This might be a good time to use one to give the defense more time, or they don't even have to use the continuous. They can just push the trial date back. Um, I think it does have an impact on who did the leak. Was it somebody from the prosecution team? Was it somebody in law enforcement? Is it a witness? Is it a expert witness? And why did they do it? Well, I don't think the why matters as much. The fact that it has been done and that they're trying to uncover who did it, I think that's important. And then how do you deal with that witness going forward? Um, and also the evidence that's mainly dealing with Mr. Bryan Kohberger's cell phone. Is that evidence going to be stricken? The pictures, the history, the 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 way the court can deal with it, they can strike it. They can say that those records, that information cannot be put into trial. I don't know if they're going to do that or not, or if they take piece by piece, possibly throwing out maybe the photos, but not necessarily the record of, say, the cell phone call log, for example, if that was brought up. They may not get rid of that because that may be relevant to something else, but maybe not use and enter a photograph that was released. I don't know. I don't know what Judge Hipper is going to do. He can grant in part and deny in part. She didn't detail bullet point style, but he can deny certain evidence, but then he can say, no, the trial is still moving forward for August 11th. I think it would be good to delay the trial because clearly the defense is not prepared. They still have a lot of work to do. And also this idea of the alternative perpetrators, I know they're going to court June 18th, 2025 to go over that further, and the prosecution would have had time to respond to that information, and the decision is going to be made about that. But she may need more time to even investigate that because Ann Taylor was recently saying, well, I've just identified this, and now I'm looking into these alternative perpetrators, which kind of surprised me because from the beginning, I thought it was multiple perpetrators. I don't know if there was new evidence found from something that the prosecution turned over, and that's what she was referring to, but it almost seemed like it was like a new idea. Whereas even her experts are saying that it was at least two people that did the murders of the Idaho Four. So that was kind of, it was kind of off to me when she said that, like, this is really not a new idea. Your own expert is saying there was possibly two killers, that it would take two killers to do the murder. So I don't know, that threw me off. So I think she's just taking the opportunity to come before the court now, especially with the Dateline special that's already been released. And then, of course, we've heard that there's going to be a book release in July. So we will see. Please let me know in the comments what you think. Thank you for spending this time with me. I really, really appreciate it. I want you to have a beautiful day. Stay safe, stay smart, stay savvy. Be well, all my friends. Bye, everybody.